Welcome back to the channel and to the sofa. I get lots of questions about how to challenge a parking charge notice. Now, this is not to be confused with a penalty charge notice, which is different. One is a fine and the other is not. The penalty charge notice, clue in the name, is a penalty, is a fine, and can only be issued by the authorities or those authorised by the authorities to do so. Welcome back. If you are new to me, I'm a barrister of England and Wales who helps you to understand law. In this video, talking about the best practices, not legal advice you understand, but the best practices to challenge or to avoid a parking charge notice. Now, there's an interesting case, Beavers and Parking Eye. Many of you will be familiar with that case. It went all the way to the Supreme Court. The underlying principle that was to be decided in that case was whether or not a parking charge notice is a penalty. Because, of course, a private company, be that a management company or otherwise, cannot issue you with a penalty. But they can, so said the Supreme Court, issue you with a charge for breach of contract. Now, I know that some viewers have very vocally argued against the notion that a contract can be formed simply by you driving into a car park and thus accepting the terms of the car park notices, which are usually displayed at the front. And by vocally, I mean typing angrily in the comments that the Supreme Court was wrong and therefore everything I say was wrong and that nobody can be forming a contract in this way. However, that's obviously not the case. It very much is the case that a contract is formed so long as those signs and notices are sufficiently clear and visible, which I'm going to come back to in a moment. But the underlying principle, which is at paragraph 94 of the Supreme Court judgment, which I will link in the description below if I remember. If I don't, remind me and shout at me in the comment section and I will go and link it in the description below. But the relevant paragraph is as follows, and I'm going to read it out because it's very interesting and explains the formation of the contract along with whether or not this is to be a charge or a penalty and the issue at hand. This is within the introductory paragraphs of this judgment to this particular case. It says, "It was common ground before the Court of Appeal and is common ground in this court that on the facts which we have just summarised there was a contract between Mr. Beavers and Parking Eye. Mr. Beavers had a contractual licence to park his car in the retail park on the terms of the notice posted at the entrance, which he accepted by entering that site. Those terms were that he would stay for not more than 2 hours, that he would park only within the marked bays, that he would not park in bays reserved for blue badge holders, and that on breach of any of those terms would pay £85. And then goes on to discuss whether or not it was consideration for the parking company and so on and so forth. And the issue really was whether or not it was a charge, which was a lawful charge, or whether it was a penalty. The court ultimately concluded it was not a penalty, but it didn't give permission to these companies to just charge whatever they like out of all proportion, because terms that are regarded to be unfair are unenforceable. So if, let's say, for example, that parking charge notice was £1,000, that would be out of all proportion, that would therefore be unfair, that would therefore be unenforceable. But £85 in this example, the court said, that's fine. So with that in mind, and for those that were still unpersuaded, just take my word for it that so long as the signs are clear and they are visible and they're available to read if somebody wants to read them by entering the car park and parking your car, you are accepting the terms of the contract. Now, there's a number of things here that I can raise as guidance, not as advice, but as guidance if you want to challenge a parking charge notice or you simply want to avoid it in the first place. Now, first of all, these signs are usually, as in this case, there were, I think it says around 20 signs around the entrances to these car park, and the terms were relatively clear for anybody that wanted to read them. It was certainly clear that the terms were there to read, and you could spend as long as you wanted to read it. Now, in one case I've been at court before now, this was in respect to the terms and conditions page of a website where the company in question had proved that the customer was on the terms and conditions page. The judge said, well, they were on the terms and conditions page, therefore they clearly saw those terms and conditions. How long they spent and how much effort they spent in reading those terms and conditions is really down to the customer. It isn't for the business to decide how much time and effort and attention that customer pays to those terms and conditions. They were certainly there and ready and available to read. And so if the customer goes ahead and orders, and in the parking case goes ahead and parks the car, that's down to the customer as to whether or not they took enough time to read those terms and conditions. They will still be bound by those terms and conditions. So some comments that have previously said, well, if you haven't read the terms, you can't be bound by the terms, that's clearly not the case. If you've had the opportunity to read those terms and you park the car, you're going to be bound by those terms. However, bringing this into a broad scope, this gives you one opportunity of escape. Because if those terms are written in minuscule, tiny writing, and better still, the other side, far other side of the car park, where you can't reasonably see it from where you are, you may well successfully argue that there were not prominent visible terms for your attention to be drawn to, so that you could have had the opportunity to read those and thus accept those terms when you park the car. Now, this is probably not going to be much use in recent years, because these companies have obviously learned from these cases and they put these signs up all over the place. You probably noticed when you enter a car park, there's one on either side of the entrance, there's one when you go in, there's one on almost every strip of bays, there's another one when you're walking out. The terms and the signs are all there. They're all typically available for you to see. But in the instance where they aren't visible and readily available to see, you might have a chance. Another opportunity, perhaps, if you're being given the parking charge notice for being parked not in a bay, i.e. you're over the lines, you're outside of the bay, or you're parking somewhere you shouldn't be, you might then look to the lines themselves. Are the lines clear? Are they clearly painted? Is it easy to see these lines, or are they covered in snow, in which case perhaps they haven't done a good enough job at keeping it clean so that you can see the lines and it would be impossible to park within the lines. And given that they want to charge you for parking outside of the lines, it's only reasonable to expect that you should be able to see those lines. Therefore, there's probably an implied obligation and an implied term of the contract that they clear the snow, or they make sure that the lines are clear for you to see. Another example might be where there are contradictory signs, where one sign is outdated by another sign, and you perhaps arguably only see the one that is more favorable to you, and the other one is more onerous, i.e. there's a shorter time period or a higher price and so on and so forth. But in consumer law and the way consumer law is interpreted, if there are conflicting or ambiguous terms of a contract, the one which is going to be more favorable to you is likely to be the one that the court upholds. And this again comes from the consumer legislation. Another example that I've seen doing the rounds on social media is when you enter a car park and your license plate is clocked, you drive around, there is nowhere to park, and then you leave, only to be clocked on the way out, and then they send you a parking charge notice for failure to pay for the parking, even though you weren't able to park your car in the first place. There's another example linked to this I'll come back to in a moment. But common sense in these situations should really prevail, in that if there is no space for you to park, or you are simply mistaken and you drive away without parking, then it is certainly arguable that you did not accept the terms of the contract because you didn't park the car. Again, some companies have got wise to this and put a barrier in place and force you to take a ticket, and say that by taking the ticket you must pay for a minimum of 1 hour. So in those cases it might be quite tricky to unpick, because by the time you've got to the barrier it may be impossible for you to reverse out. So then it might be a case of looking for, well, how far in advance of this car park were the signs to tell you that if you go in you must pay for the minimum of 1 hour. There is also a very interesting new code of practice introduced by the government, which it is forcing companies to comply with by the end of 2023. This code includes, among other things, a mandatory minimum cooling off period of 5 minutes, in which motorists can consider the terms and conditions and change their mind about parking. It aims to clamp down on difficult pseudo language that makes it difficult to understand the terms of parking. Of course, a requirement for parking firms to clearly display pricing, terms and conditions of parking, contact details on how to appeal a charge, and my personal favourite, mostly because of the wording, a compulsory 10-minute grace period before firms can issue a late fine. Now, bearing in mind that this guidance is targeting what it calls Cowboy private parking firms, and given the discussion that I told you about at the Supreme Court that concluded that these are not a fine, it certainly goes some way to showing that everybody essentially sees these parking charge notices as a fine, much to the dismay of one of my lovely keyboard warriors the other day, asking why I referred to it as a fine in the thumbnail and maybe even the video, when actually, of course, it is a parking charge notice. That is simply because this is what everybody sees this to be. They see it as a fine, even though it's not legally and technically a fine. It's consideration for the management of the car park because you've broken the terms and conditions of parking. You're in breach of contract. Essentially, it is a charge for being in breach of contract. Interestingly, you will also be happy to hear that parking debt collectors will be banned from adding additional excess fees to the level of parking charge, which is currently as much as £70. Motorists will be offered a 50% discount if they pay within 14 days, and new parking charge levels will mirror the local authority system for publicly accessible car parks, halving the charges for millions to £50. It will keep the current £100 cap in some circumstances, such as using blue badge bays or if a motorist is trespassing on private land. So very broadly speaking, if you want to appeal and challenge these parking charge notices, if you really believe that you have a case, then I would suggest you don't pay it, or if you do pay it, make it absolutely clear that you are paying it but you intend to sue to recover it, and you're only paying it to stop them from adding further charges, but then you intend to take the case to court to get the money back. Or, as I said, at the risk of them adding further charges, if you believe that you have a strong case, and this cannot be taken as legal advice, but if you believe that you have a strong case based on some of the suggestions and guidance that you find here and elsewhere, then you can simply let the company take you to court and let the court decide. However, this comes with the warning that if it is found that you did have the opportunity to read the terms and conditions and you parked your car and you overstayed, bearing in mind that this parking code, which is known as the Parking Code of Practice Act, became law in March 2019. And firms that do not comply with this by the end of 2023 could be banned from accessing the DVLA database so as not to be able to gain your details. So as I say, this code is a very interesting development. These are broadly the ways that I would seek to challenge a parking charge notice. So do let me know your experiences in the comment section below. Please like the video and subscribe. And as always, thank you for watching.